Welcome to the Good Reading Magazine podcast, sponsored by Pantera Press. Good Reading is a monthly magazine dedicated to books and reading and aims to help readers discover their next favourite book. You can find out more about the books discussed on today's podcast at goodreadingmagazine.com.au.
Hello and welcome back to the Good Reading podcast. I'm Max Lewis, and today we're joined by Burmese-Australian barrister and former criminal defence lawyer Andrew Bowe, talking about his debut book, The Truth Hurts, which provides an unflinching outside perspective on the faults of Australia's justice system. Bowe takes us from cases of Indigenous deaths in custody to cases of self-defence after years of domestic abuse, from defending Ivan Milat to defending Pauline Hanson. He spares no one, not even himself, to explore the human cost of not getting to the truth. Andrew, thanks so much for joining us today.
Thank you very much for having me on your show.
So you began writing what became The Truth Hurts back in 2011 to process a particularly tough case you just finished regarding the death of a couple in the Gibson Desert. How did the book develop between that first chapter and now?
Well, when I'd finished writing it, and it took me a long time to do that, and I had no aspirations of doing any more. My partner said to me, look, why don't you start writing again? Because when I was doing that, I was probably more sufferable for her domestically. And I realised that there were other stories which may be of interest in being catalogued. So I sat down and over the space of about 6 months or so, wrote about 10 stories, and each of those were cases which others that I'd been speaking to thought and reminded me about. And I hadn't intended it to be a book which did anything more than just say those stories.
Yeah.
And so that was the state that it was in for when I finished it. And I happened upon a friend who'd written a book at a launch, and an agent, my current agent, asked if she could read it, and she came back and went off and negotiated, a deal with 6 or 7 publishers who wanted to publish it. So the pressure was on at that point to turn the manuscript into something more readable, and each of them thought that it was necessary to put more of me into the book to explain the context within which I was making these observations, and I resisted it, and I didn't do that very well, because I think there is more in the book about me than I feel comfortable with, but it seemed to have made sense that readers may wish to know the perspective that I was bringing to the cases that I was commenting about.
Well, why did you not feel comfortable having so much of you in the book?
Because I didn't want to write a book about myself.
Yeah.
And not quite ready to write a memoir. So if I was ever going to be ready, and I would not have thought of doing it. As I say, my plan was to rid myself of the grime, as I call it, of this sort of practice. And in the end, I guess to make it more readable, there's a perspective in there of a personal kind.
And you mentioned ridding yourself of that grime, and a lot of the cases that you bring up in this book are quite shocking to read in some parts. How did you navigate going back and revisiting these difficult cases that you'd had and your role in them while you were writing the book?
Yeah, it wasn't easy to do. I don't think professionals, whether you work as a lawyer or as a emergency surgeon or in a mine, I don't think we realise that we do accumulate baggage and trauma from delving into the lives of other people, and the circumstances in which they encounter what must seem to them to be a very strange system. I mean, the criminal justice system is unwieldy and it's complex, and because I'd learnt a few things about it, made it easier to navigate it, but that doesn't really protect people from the harm that the system does to people.
And as somebody who doesn't come from a law background like I do, I think the book strikes a really good balance between being very informative about the legal processes in Australia, but it's also not too complicated. How did you go about making sure the book was approachable for the average reader?
Yeah, thank you for that. I get bored reading legal books. I get bored reading legal biographies. And just hearing war stories from a lawyer's perspective is sometimes a bit egocentric and focuses a lot on technical jargon, etc. The cases I've covered, which deal with things such as traditional punishment and how, when that is performed, how that interfaces with the criminal justice system, domestic violence, political corruption, extreme sexual violence, the issue of consent. These are all matters about which many of us who are not lawyers, many people who are not lawyers think about and talk about and read about, etc. So although I might have missed your question, I just thought it was necessary to speak in a way where people would be engaged with the story and not the legality, even though the legal framework I think I have got correct. And I had an enormous amount of help from my editor Meredith Rose, who has edited quite a few great non-fiction books like Chloe Hooper's The Tall Man. And Chloe put me onto her, and Meredith was extraordinary. She was able to question what I meant by a particular paragraph or a point, etc., and interrogate me as a reader might and say, what are you talking about here when you use these terms, etc., etc. So that took a lot of revision, and that process took close to a year, frankly, of me enjoying her criticism and her sense of humour and trying to make sure that something is not lost in the detail. I mean, nobody needs to know all the legal detail, but they need to know how the law works, how it affects people, and how the process unfolds.
Many chapters in the book cover the massive problem that our justice system has with regards to Indigenous people, whether, as you mentioned, it'd be our laws clashing with their laws, or, at the time of this podcast, the massive amounts of deaths in custody that have led to no convictions. In light of the increased scrutiny on these events thanks to the Black Lives Matter movement, do you think that some of these problems might start to be addressed soon?
The fact that more non-Indigenous people are engaged with the issue is, of course, a good thing. That it took the death of an American for that to happen in this country says a little bit about who we are as a country. And so I don't necessarily think that social media and other attention is necessarily going to result in political change. And the matters of intransigence abound when you look back at history. So the current statement from the heart, the Uluru Statement, is stalled in political circles, yet it's a matter which is simple in its design. It simply is asking that there be an official recognition that there's a need for parliamentarians to be informed about the impact of the laws that they are promulgating from a body made up of Indigenous voices and intellects who can explain these matters to Parliament in a better way by commentary. They don't have a right of veto to stop the law, but they have the opportunity to systemically provide details to government when they enact these laws. Now, the fact that that is resisted and not greatly supported by both sides of Parliament because it's a politically difficult issue is still there. It's not going to change. And as I speak about in the book, and it's not just about Indigenous cases, but it is a significant matter of conversation in the book. I can only hope that we do more than march and protest and write emails and engage in social media. We need to share the experience of the other. It's only when we break bread, we live with, we engage with, we learn from other people that we actually see them as human. And at the moment, that divide hasn't yet been crossed in my assessment. Look, there's some great sparkling examples of it working. There's some extraordinary people who work in this space. But the general community, I don't think has yet reached a point where their understanding is not about a problem, but about a sense of humanity, about another shared experience in the world in which we operate. And for that to happen, hearts and minds have to change, and a lot more conversation needs to take place.
One of the other ideas brought up in light of George Floyd's death is that there's been a push for the defunding or even the abolition of police forces in America and even in Australia. I'm curious what your thoughts are on that, and if you think it's even feasible to happen in Australia.
Yeah, well, I think there's perhaps some misconceptions about what defund the police as a proclamation really means.
It's kind of become a bit of a catchphrase, yeah.
Yeah, if it means to reprioritise resources that are given to equipping police forces with military level weaponry, and to divert that towards areas in which crime is diverted, or where communities are empowered, where there's much more regard for the medical causes for drug addiction rather than it being a legal offence, where Indigenous people are given more space to be able to talk about their educational and social and housing limitations and how crime to poverty are committed. Well, of course, I mean, that the sort of project that Australia needs to embark upon, and there are examples of that, and strong examples of that. But if the notion is that we no longer need police to police communities, or that somehow crime, which does exist, will be less occurring if there's less police, I mean, I think that's a naive fallacy. I'm sure those who are the proponents for it mean the former rather than the latter. Those who are in the polemic response to this on social media go to the simplicity of the words and criticise it, and rightly so. So sloganism is I mean, it's useful to get likes on social media, but it doesn't really advance the conversation. They're just as Reinvest, a program that's been working out of Burke in dealing with engaging the whole community in ensuring policing to take responsibility at a community level for crime and rehabilitation, etc. Well, they're no-brainers. Of course these things should happen.
And there's a particular quote from the book that I think sums up a common misconception about Australia's justice system, where you say that Australia's criminal justice system was not designed to seek the truth. I was curious if you could elaborate on that a little bit.
Sure. Focusing firstly on the criminal justice system, as I've written in the introduction, the adversarial system, that is where one party argues against another in court, prosecutor on one side and the defence lawyer on the other, it is not designed and never has been intended to identify what the truth of the matter is. All that a court does is assemble the relevant evidence, and that relevance is determined by a trial judge, and then put that in front of a jury and have both sides argue about the cogency of the evidence, and then to determine on a very high standard, beyond reasonable doubt, whether or not that which has been alleged by the prosecutor has in fact been established to the necessary degree. It follows from that there are many steps along the way where the truth is evaded. Firstly, trial judges don't decide what evidence comes before them. It's in the hands of the police and the prosecutors. A trial judge only applies very complex rules of admissibility to make sure, under these very historically based laws and provisions, as to what can a jury safely hear. There's been a long debate, for example, about to what extent events, acts of the offender prior to this particular event can be used to infer the guilt of the person. So sex cases are an example. Whether you look at whether or not things they've done in the past can be not proven, but things done in the past can be used to infer guilt. And that's called tendency and coincidence reasoning in New South Wales, or propensity in the common law. So can somebody be convicted on evidence of somebody's propensity? Now, 20 years ago, the law was pretty clear. No, it couldn't, unless it fit a really narrow band of being so similar. Now we have a situation where a person can be convicted mostly because the Crown has proved that that person had a propensity to do something. That doesn't get to the truth of that particular offence. Secondly, when you talk about courts, much of the work of judges is to exercise discretion, is to decide on a particular test whether or not something should go in or should not go into a trial. Now, the judges who exercise the discretion historically have been chosen from a very narrow band within the community, white middle-class men, whose exercise of discretion may well differ with people from a different demographic, even women. So the filters under which evidence comes before juries, we have this mystique about the law that somehow when a judge makes a judgment that it's got some fundamental truths in it. It doesn't. It simply has the application of law, the exercise of discretion by an individual lawyer who's been chosen by politicians to fulfil that role. So what I was trying to get to, not so much that the system doesn't necessarily work in that sense, but rather if you're looking at verdicts to determine the truth, you're going to be hit and miss about that a lot.
And on the topic of misconceptions, the role of a criminal defence lawyer, as you were for many years, it's an often misunderstood one. What misconceptions or stereotypes about that did you want to clear up in your book?
Well, I've done a fair bit of that, and I still work as a criminal barrister. I don't know if I'm wanting to persuade anyone that these misconceptions should be disabused. I mean, much about every area of endeavour is unknown to other than those who practice within it. I guess what I was trying to put out there is that some of the naive or ill-informed biases about the law, if they were explained in a way that people understood it as they might apply to them, it would elevate the discussion, to one that's more closely related to what actually happens. I mean, people sometimes ask, how can you act for that person when you know that they're guilty, for example? How do you feel about having done that, etc.? Well, I've sought to explain that. People talk about, why do you choose those particular cases to do? And I explain those sorts of things. So it's not a lecture. I hope the book is not all heavy. I mean, there are, I think, some lighter moments in it. I'm trying to provide a human perspective to a system that many people don't know much about in real terms.
There's a phrase that you use at the end of the book, which I think sums that up really nicely, where you say there can be no solutions without first acknowledging problems. And I think the book does a great job of doing that. And I think you touched on this a little bit before, but with that knowledge in hand, what can us readers do to push for more change with our legal system?
Yeah, these are big subjects, and I don't pretend that my book is anything more than a small book about the things I noticed. I want to make that fairly clear. The reader shouldn't read me as an expert in this area. I think the reader should read me as being a person that's willing to explain some things they noticed so they can make their own evaluation of these matters. I think that when there's more engagement where people are not yelling at you, I don't think you can persuade many people, or I don't think you can persuade most people of many things. There's a significant minority that is pretty set on particular views. Where the divide is in this country, whether it be in relation to Indigenous identity and relationships with Indigenous Australians, whether it be how we're addressing COVID-19 issues, how we're addressing climate change. So I don't have the lofty aspiration that's going to change anything. I'm hoping that it's a good read for people who want to understand a few more things about the criminal justice system. And not just the criminal justice system, because I deal with cases other than criminal cases. The hope is that with this sort of information, others can be critical of what I've written, provide a contradicting perspective if necessary, and elevate the conversation to a level where when we get to the essential issues about which we are in disagreement about. If that can happen, much can be achieved. Just get rid of the chaff so that we can see more clearly the system we have. I describe a system where many cases funded by government in terms of legal aid or public defence, where barristers, young barristers, are picking up briefs a day or two before a trial starts. That's the level of justice that many people receive. And I guess until one of us or our children or friends face a criminal justice system, we do realise then at that point how arbitrary the system is, even with people with enormous resources. I mean, as I've explained in the book, I've acted for billionaires and people with extraordinary resources who've expended enormous amounts of money in defending themselves, and even they see how arbitrary the system can be. Whilst we can talk about these things in this sort of conversation, in the jury room, we don't know what happens in there. And all of us are very good at covering up our prejudices and making sure that what we want known about us are our virtues. So when we don't talk about those little noises in our head where we sometimes do act in a discriminatory way, or we make an assumption about something on race, class, whether it be that we make an assumption about somebody that drives a BMW as opposed to somebody who walks around barefoot. We have a lot of inherent prejudices in us. A system which relies on fellow citizens to determine the guilt of another has to make sure that those prejudices don't inform the result. I'm hoping that the examples I use trigger a conscientious sense that we have a social responsibility. This social contract that we enter into in living with each other has to be informed in a way that looks at these examples and sees that sometimes these sorts of things happen, and if we face them, if we face the reality that these things happen, then we can do more. When we can see that it disproportionately is less than perfect for some classes in our community, we have a real responsibility, if we are in the broader class, to make sure that we don't leave anybody behind. I listened to Paul Keating give a video of him giving the 1993 Prime Minister's speech in relation to the International Year of the Indigenous Peoples. It was extraordinary that a Prime Minister was speaking like that in 1993, which is 27 odd years ago, and that those same words could be spoken by any Prime Minister now, and those same frustrations that he was speaking about are still there. All those issues that he was troubled with, the inability of white Australia to embrace their responsibility, to recognise that there's really one great poignant line in it. He says, when will we accept that by putting our hand back to pull somebody up from behind us does not necessarily mean bringing us down? And I think it's that sense that I want to evoke, a sense that a system was designed by colonisers who came to this country in order, under this extraordinary lie that nobody else lived here beforehand, set up a system of justice, whether it be criminal justice or otherwise, which was there to privilege those who came with them and who couldn't see that the community would grow as it has to the country that we have now. Now, if we don't have a system that embraces what is our current manifestation, which hasn't got a gendered view, which hasn't got a colonial view, which doesn't have a racist view, then protests like Black Lives Matter will grow and grow and grow as the discontent increases. I mean, the tragedy of deaths in custody in Australia is as stark as that in the US. and there's 2 cases I write about in the book about that. So, and to think that the Palm Island case was nearly 20 years ago, or 17 years ago, and not much has changed.
It's been 20 years since the Royal Commission into the Aboriginal deaths in custody, and nothing's changed.
Yeah, so they're the reasons that the book is in its current form. I didn't, as we've spoken about, I didn't set out to write any book, but the book that we've all collaborated on and got out there soon, hopefully will provide a further addition, a small addition to the conversation.
Oh, let's hope so. Well, Andrew, thank you so much for joining us today.
And thank you for your time.